Hi everyone, I'm Isabel and I'm a real student here at the University of Toronto. I'm a student co-leader of the Asper Center Working Group on Indigenous Child Welfare and Self-Governance. And I want to start by acknowledging how grateful I am to be learning about Indigenous law and governance on the traditional territories of Mississauga, the Québec, the Rwanda, and Seneca. Today's panel is a really great opportunity to learn more about the ongoing practice of Indigenous legal orders across Turtle Island, and I'm so grateful to Professor John Burrows, Dan Mingle, and President Blackhawk for joining us today to talk about this. I'm just going to briefly introduce our working group as well as the two cases we will be discussing today before passing it off to Cheryl to introduce the experts and start our discussion. So following our amazing first year course on Indigenous peoples in the law with John Burrows, Gabby, Brianna, Jules, and I wanted to explore two cases in the US and Canada that were determining the validity of federal legislation introduced in both countries to address the historic and ongoing harms caused by the apprehension of Indigenous children from their families by settler governments in both countries. In the Canadian context, Bill C-92 and its affirmation of a generic and inherent right to self-government over child and family services felt like a moment of transformative change in Canadian law and for Indigenous nations. And we thought this brought up really interesting comparisons with the American context. With the support of Professor Burrows and Cheryl Milne and Tal Schreier at the Asper Center, we organized a group of really dedicated first and second year students to learn about and research these two areas and cases. And oriented by the goal of organizing this panel eventually. Our working group had to get really creative last year because we had to wait for the Canadian Supreme Court decision to be released before actually organizing this panel. But we were able to work on some really interesting projects last year, including presenting to Professor Burrows' first year class about Bill C-92 and the reference, and actually Navia and Ben did that with me and some other co-leaders. So thanks for being here again today, guys. And we're also working on an ongoing effort to make a podcast on the subject. The other co-leaders and I are so grateful to all of our working group members, as well as the Asper Center and Professor Burrows, and could not have made this panel happen without them. So now I'm just going to briefly introduce the cases before I pass it off to Cheryl. So the first case, the Canadian case, is the reference regarding an act respecting First Nations, Inuit, and Métis children, youth, and families. And this case is a reference submitted by the Quebec government to the Quebec Court of Appeal, asking whether the act exceeds federal jurisdiction under the Canadian Constitution. The act was introduced by the federal government in 2020, and it affirmed the generic Aboriginal right to self-government in relation to child and family services, recognizing self-government as an inherent right affirmed by the Canadian Constitution under Section 35. The federal act defined a path for Indigenous people to exercise legislative authority in relation to this law to prevail over existing provincial laws to the extent that there's a conflict or inconsistency between these two laws. The Quebec court found the act to be valid except for the provisions that dealt with conflicts and paramountcy and affirmed the generic constitutional right to Indigenous self-government over child and family welfare. The decision was then appealed to the Supreme Court, and the Supreme Court overturned parts of the QCCA decision. The Supreme Court upheld the act as a whole as constitutionally valid, recognizing that the focus of the act is to protect the well-being of Indigenous children, youth, and families by promoting the delivery of culturally appropriate care and family services, and this purpose advances reconciliation. However, the Supreme Court's approach differed from the Quebec court's approach in that the vehicle for constitutionality of the legislation was a federalism analysis rather than finding a generic Section 35 right to self-government over child and family services. The Supreme Court found the act as a whole to be a valid exercise of federal power under Section 91.4, federal jurisdiction over Indians and land reserved for Indians. In addressing Parliament's explicit affirmation of an inherent right to self-government, the court held that the affirmation was an expression of Parliament's position on the scope of a Section 35 right, rather than any amendment of the Constitution or actual recognition of a Section 35 right. So this approach, interpretation of the Act ultimately avoids the question of whether or not there's a Section 35. Section 35 includes an inherent right to self-government. And I think that this approach leads to a lot of theoretical and practical questions that we're going to explore further today. And then in the American context, the 2023 Haaland and Brackeen decision rejected another constitutional challenge to the Indian Child Welfare Act, or ICWA. So this case was brought by the state of Texas and some states, as well as several individual plaintiffs, and alleged that ICWA was unconstitutional. ICWA is a federal law created in 1978 that governs the removal of American Indian children from their homes. The law prioritizes placing American Indian children who were removed from their homes first with family members, and then with families within their tribe, and then with American Indian families generally. So there were arguments made by the plaintiffs that focused on ICWA as a law prioritizing placement of children based on race, rather than thinking about and understanding Indigenous nationhood and sort of these arguments misconstrued Indigenous legal differences as being predicated on the basis of race rather than nationhood and the unique relationships to land in the Americas. So these arguments have really far implications for Indigenous self-government in the U.S. beyond child welfare and also within the field of child welfare and the next part of this information today as well. So I'll pass it on to Cheryl and introduce the panelists. Yeah.
Thank you, Isabel. Did you get all of that? I really want to welcome our speakers today. We have on screen. Are we hearing it? Okay, should I use the microphone? Is that better, Maggie? Okay. We have first Maggie Blackhawk is a member of the Fond du Lac Band of Lake Superior, Ojibwe, and is a professor of law at NYU School of Law. She's a prize-winning scholar and teacher of federal Indian law, constitutional law, and legislation. Her recent projects have focused on the laws and legal histories of American colonialism and the central role of the American Colonial Project, including the resistance and advocacy of Native and other colonized peoples in shaping the constitutional law and history of the United States. At the end of the table, we have Sarah Mainville. She's a partner at JFK Law, LLP, and is a member of the Ontario and British Columbia bars. In 2014, Sarah was elected as chief of Couchiching First Nation after the sudden death of her friend and mentor, Chief Chuck McPherson. Sarah uses this experience as a former chief to help leadership work past difficult issues within Indigenous forms of dispute resolution and walk communities through processes to encourage discourse and grassroots solutions to long-held problems. Sarah is a subject matter expert about Crown Indigenous relations, the United Nations Declaration on the Rights of Indigenous Peoples, Treaty 3, and Anishinaabe, and please correct me if I mispronounce this, and an Ojibwe word that means a law, a ruling, or an agreement. Did I get that right? No. Okay, thank you. And John Boris, to my immediate left, is the Loveland Chair in Indigenous Law at the University of Toronto Faculty of Law. He's a member of the Chippewas of the Nolish First Nation in Ontario, Canada. In addition to his numerous publications and awards, such as Canada's Indigenous Constitution, which won the Canadian Law and Society Best Book Award in 2011, he was appointed as an officer of the Order of Canada in 2020. So welcome to all of our speakers. And I'm going to start with a question for Maggie. Could you briefly describe the American approach to tribal sovereignty, especially the plenary power and the inherent rights doctrine? And there's a subsequent and follow-up question to that, which you can address as well, which is how did the issues and arguments in the case Haaland and Brackeen connect to a broader attack on tribal sovereignty in the U.S.?
So thank you so much for those questions. Bonjour, Maggie Blackhawk, Indigenous. Maggie Blackhawk, I teach law, as you heard, at NYU Law School, and I'm Fond du Lac Band Ojibwe. I think in beginning with your question, maybe I'll start with Brackeen as a point of clarification for both what we call the plenary power doctrine and the inherent rights doctrine. But in many ways, they can be simplified, and Brackeen does begin the process of simplification, but also confuses in certain senses. So we'll start there. So in 2023, the Supreme Court clarified at the very least its position on the power that the United States holds to colonize Native people within its territorial borders. And it held there in upholding ICWA in part, so against one particular challenge, which was that Congress lacked the power to pass ICWA at all. It upheld ICWA, saying Congress had that power because the Congress has the power to colonize Native people within the territorial borders of the United States. And that power, the court said, arises from the Constitution of the United States. And it began with both the treaty clause and the Indian Commerce Clause, which we know are in the text of the Constitution. And then it turned to something interesting, which was a claim that the structure of the Constitution included in it the powers inherent in sovereignty, which is an odd term that captured a body of law and a vision of law of the 19th and 18th centuries, where the United States, its founders, and the majority of its government believed that the United States Constitution was thick with the law of nations and natural law. And within those bodies of law were the powers of civilized nations to govern other savage nations through forms of colonization that included protectorates, trusteeships, etc. That doctrine over time was even recognized by the Supreme Court. So this wasn't just, it was a doctrine that really built out of the executive and legislative acts of colonizing Native people, of trying to conquer them through war and exchange through treaty, but then to actually govern them directly through legislation passed by the Congress. And they believed that they had the power to do that because the US was a civilized nation and because Native peoples were not. They had governments that were recognized, but they were savage governments. So they were lower within the hierarchy of civilized nations, and certain aspects of the law of civilized nations didn't apply to them. So they believed that that power existed. In the 20th and 21st century, so the Supreme Court in the 19th century, in the Marshall Trilogy, codified that doctrine, the law of nations, to see Native nations within the US territorial borders as domestic dependent nations. And that doctrine was really flattened in the 20th and 21st century as the US became less comfortable with the law of nations and natural law informing its constitutionalism. It began flattening that doctrine into something it just called the plenary power doctrine, where the court began to articulate a vision of American colonialism that allowed the political branches to have plenary power, meaning the courts wouldn't use its own review power to oversee the process of American colonialism, as it had done similarly in the 18th and 19th centuries, but it wouldn't explain why. It wouldn't delve into the law of nations or natural law like John Marshall had done during the Marshall Trilogy to articulate domestic dependent nations. Instead, it would just defer. It would allow those branches of the United States government plenary power within these areas. And we've seen the plenary power doctrine extend to many areas of law that were formerly law of nations, natural law doctrines, mostly external, so foreign affairs, immigration law, all are now subject to the same plenary power doctrine that we see Indian country, the territories, the governments of another colonial government of Puerto Rico, American Samoa, and Guahan. So we have here, that is the doctrine of the power. And Brackeen, again, reinforced that doctrine just in 2023. The Supreme Court reinforced it. The inherent rights doctrine is a broader and longstanding effort and through different forms and facets of colonized people, and mostly Native people, to argue largely from the law of nations originally that the United States should recognize at least partial sovereignty in the people that they're colonizing within Native nations, but also in Puerto Rico, American Samoa, Guam, the Philippines moved toward independence, but that Native peoples would argue for a form of sovereignty that would both shield them from the American colonial project and shape their own forms of self-determination within the context of American colonialism. And that form of recognition has existed from before the founding, where the US formed treaties with Native nations, and then Native nations argued from those treaties and from the law of nations that they deserved recognition. That recognition was codified into a super statute in the 20th century called the Indian Reorganization Act of 1934, and has since structured the government-to-government relationship between the US and Native nations ever since, at least the ones that are recognized by the federal government. So both of those doctrines, I think, have deeper roots and more malleable contours than we imagine them. And in Brackeen, the court reaffirmed the power of American colonialism, but began to express, as it has for some time, concerns over limits, especially because since it's turned to this 20th century and 21st century vision of its own constitution, it is uncomfortable with the idea that any power that arises from the US Constitution isn't subject to the limits of that Constitution. And we can see similar confusions and battles as it tries to apply its Constitution to the power to colonize Puerto Rico and the power to colonize American Samoa. You can see similar concerns of how do we now have this power to colonize, but now we're going to actually apply things like our equal protection doctrine to Samoa, where their property system is set up in such a way that it is the foundation of their government, and it might be subject to complete erosion through the imposition of the US Constitution upon them. In many ways, it's another layer of American colonialism, where now we're going to actually apply our Constitution and our own vision of what constitutional rights should exist and structures of government should exist to these other colonies in ways that we haven't before. So Brackeen was this apex case where many worried that through an equal protection challenge to all of the laws that structure American colonialism, that entire titles of the US Code, including Title 25 Indians, would be rendered unconstitutional through certain challenges. And there is one law firm, but I'm sure there are many organizations behind it. Gibson Dunn, who's been bringing cases, who brought Brackeen, who's bringing a similar case now called Maverick Gaming in the Ninth Circuit to challenge the Indian Gaming Regulatory Act, as well as bringing cases to try and apply birthright citizenship to the territories, another colony, to ensure that the US Constitution similarly applies there to shut down their independent forms of government. So the Brackeen is the odd place where our visions of 20th and 21st century constitutionalism are now getting turned towards furthering the American colonial project. The irony is that our Reconstruction amendments, that constitutional values that we elevated to help solve the failure of human enslavement, will now be turned towards the furthering of American colonialism today. And Brackeen is one of those cases.
Thank you very much. I want to turn now to John. And the Supreme Court of Canada's decision in the Bill C-92 reference of how the legislative affirmation rather than the constitutional recognition approach to Indigenous rights. What might the risks and rewards or the implications be of this approach?
So in light of the prior words by Professor Blackhawk, there is a colonial dimension to this, because if you can have the federal government enact law dealing with Indigenous child well-being, that same government can withdraw those laws in a subsequent parliament. And the resting of the exercise of jurisdiction on the federal authority doesn't recognize an independent source of power that would be sovereign or inherent in the First Nation or Métis or Inuit group to be able to take responsibility in relationship to their children. And so there is something of that colonial heritage that's also present in this decision. It's also the case that the court looks to the acting as if. So the court says that court says the Crown in passing Parliament in passing the Bill C-92 legislation is acting as if there is the inherent right to self-government under Section 35. And that acting as if is not clarified by the court. They're not going to commit themselves at this juncture to uphold or deny the fact that Indigenous peoples might have an inherent right to self-government in relationship to their child and family services. And that also presents a challenge for the Indigenous parties. On the other side of this, the incrementalism of recognizing and affirming the right to self-governance is quite positive. It's very strong. Parliament binds itself to proceed as if that right already exists, even though the court is not committed to recognizing the underlying nature of that right. But the incrementalism allows the parties to gain experience in exercising responsibilities in regard to child well-being, and that will be considered as a future case when we're outside the reference context, and people will have built that experience on the ground level.
So just by way of follow-up, so this, in the American approach to tribal sovereignty is operated through legislation across many different areas of, or eras of policy. What lessons can Canada learn from how tribes have reacted to or participated in this legislative approach? And that's for you, Maggie.
I think this is to build upon Professor Burrows' description of the Supreme Court case and the Canadian Supreme Court case, and the somewhat confused approach to recognition as a constitutional power and function that he described, where it sounds like at least the Canadian Supreme Court is leaving it open that through this legislation, Canada has recognized the inherent sovereignty of Native nations to self-govern, or First Nations to self-govern within the territorial borders of Canada. So let's take a step back into what's actually happening in the US. We have confused what we've been doing quite a bit, in part because the recognition power in the context of colonialism is just confused. Because it's not full recognition. We have a foreign recognition power that is lodged in the executive and the legislative branch, and it is, as Professor Burrows described, a power that ebbs and flows, that could be pulled away with different presidents and different Congresses. However, that recognition is a separate step from the evidence of that recognition. And so in the US, we've often made the arguments that the treaties, or even the Marshall Trilogy, recognizes the inherent sovereignty of Native nations. And that is, those are evidences of that recognition. But the recognition is something that is broader, and that would still exist even if every single treaty were broken and every single piece of legislation were withdrawn. You would then need a separate step that terminated the recognition of those tribal governments as sovereign, even if you destroyed all the past evidence of it. And so the view of recognition, and it's not even just piecemeal. You could say that the legislation is unclear and maybe a conditional form of recognition, so it's only a partial form of recognition over a certain level of jurisdiction. But that's a separate question to my mind, and would have to be hashed out and shouldn't be conceded that the statute is itself not just it's a partial form of recognition. It would need to be, you have recognized us with this statute. What are the contours of that recognition, which have nothing to do with the actual content of the statute itself, but with what recognition looks like in the context of American colonialism. And at least within the US, we have had a baseline vision of recognition. So at least following Worcester v. Georgia, but if not before, recognition of a tribal government, and especially delineation of that tribal government's territorial borders through treaty, through executive order, through legislation, which we call treaty substitutes. Everything past treaties just became really treaty substitutes, which need to be interpreted with actually the full set of sovereigns informing its interpretation, including the tribal governments that are often collaborating in that formation of those treaty substitutes through legislation and executive order. So if you have borders and you have recognition of that tribal government, there are baseline presumptions of what happens in that context. We could call these constitutional rules, and I think that they are. But one constitutional rule is that a recognized tribal government excludes state jurisdiction within its borders. So the sub-national governments in the US, their states, would be excluded jurisdictionally within the borders of that recognized sovereign's territory. That would allow, at the very least, certain forms of criminal and civil jurisdiction over that territory, as well as in the US, there's a presumption against the intervention of national and state law of general applicability. The US may have plenary power to regulate Native nations directly, but we're not going to allow it to just pass labor laws for the whole country and have them silently apply to Native nations. They need to actually say so at the very least to be able to do that, which allows a political check or allows Native people to arrive and have a conversation to know when laws are going to be applied to them directly. And so recognition has a big body of baseline laws that are completely distinct from what actually is happening in the evidence of that recognition. You don't necessarily need a law that says we're going to preclude X within your territorial borders, because the act of recognition does all of that as part of what it means to be a recognized government that's colonized by the United States.
Thank you. I want, following up on that, I want to now turn to Sarah and the sort of practical implications of the Bill C-92 case and the legislation itself. So what mechanisms will be available to Indigenous governing bodies here in Canada to enforce their own laws, sort of following off of what Maggie has said, and how will these mechanisms interact with existing provincial enforcement systems and laws?
I feel very humbled to be on this panel and having Maggie I talk about U.S. Constitutional law in this way. I think a lot about these things, but my clients do want me to answer these types of practical questions. But I think in this conversation, it has to be said, like I'm from a nation that was dissected by the Canada-US border. So I have a sister community when I was chief that I immediately went to visit, which is Bois Forte tribe in Minnesota. And I think because of my grandmother, I think I actually could be a registered member of the Red Lake tribe, because that's where my grandmother's from. So it's so strange that we have such different realities because of the early US constitutional law and this idea of reserved rights in treaties, and it's quite different. And so practically, the one thing I sort of one of the messages I want to drive home is we still have the Indian Act, and we still have 19th century governance under the Indian Act. And the governance capacity is something real that we don't have. And so I work for my nation, the Anishinaabe Nation in Treaty 3, which is the boundary waters of Minnesota. And we've been talking about jurisdiction and law in the early days of Haida Nation coming through the courts, and we created a Manitoulaki and Okanagan, but we didn't have the governance capacity to truly operationalize it. And we created Abenuji and Okanagan in 2002. We had drafting instructions, and then we went on to have our law. But again, that governance, the lack of governance capacity is our original nation. When we made treaties a nation. So 28 First Nations that are under the Indian Act largely, and the lack of capacity. Like if you go to a self-government agreement, you get about 19 times the governance capacity that you have under that support system in First Nation. So practically, as an Indigenous governing body, most of my clients are chief councils. And we work to try to create written laws as a guide to live in sacred Anishinaabe law in Okanagan. But the Act does help for sure. And just turning to specific sections of the Act regarding mechanisms for IGBs, as we do, we always like to use acronyms. And we still say Bill C-92 because it's not a nice acronym on that Act. So Section 21 sub 1 provides that a law of Indigenous community or nation who has entered into a coordination agreement or made reasonable efforts to do so for 1 year will have the force of federal law. So that's very helpful. That's that innovation has really helped to resolve things in advance of coordination agreement negotiations. So I've done negotiation strategy for WAPs among Independent Nation, who was with the first coordination agreement in Ontario, with Ontario and Canada, and I'm just going into a coordination agreement negotiations for Saskatchewan Nation. And so this really helps. One of the things that in our law firm, and Isabel will know this, is like we really needed to sketch out sort of roadmap what we needed coordination agreements to do after the Bill C-92 decision and what we needed the written law to do. And one of the real important things with the written law is to be really careful about how you talk about the source of your jurisdiction, because Bill C-92 is doesn't resolve, where that, you are in fact inherent right to self-government holder. So that's one of the things. Of course, Section 18 recognizes the inherent rights of government, the authority to administer and enforce laws, and the authority to provide for dispute resolution mechanisms. So there's an interesting interplay with those two things in the public-facing laws that we see under Bill C-92. And I'm really behind with the first generation of laws because they actually kind of look familiar. They don't look all that distinct from provincial child welfare laws. But you're going to see, and I can't wait till one of our clients' laws are public facing, because we can talk about how they actually work in Anishinaabe constitutionalism. And enforcement is the wrong word under Anishinaabe constitutionalism, by the way. But I think so one of the things that seems to be an active conversation, and where we do a lot of like second opinions on some of this for other lawyers, is whether or not according to the courts on disputes is something that the law is going to do or not do. And we've seen again public facing laws like Big Wakanagon says that the law is outside the jurisdiction of the Canadian court. And then there's others that say that there's going to be a time frame where the courts can be involved, but eventually the tribunal is created through the law is going to have the jurisdiction. So there's different approaches. I really like Cowichan's approach. So my good friend Sarah Morales had worked on that in actually having provincial law change to accommodate the new jurisdiction standards in Cowichan. So all really interesting, but this is some of the sort of elegance of the Bill C-92 law that's available. There's tools there, as well as the coordination agreement. There's a lot of real work the coordination agreement has to do around jurisdiction.
Follow up with that, John. So while the court upheld the act under federal jurisdiction, how does the decision impact the existing division of powers regarding child welfare between federal and provincial governments? Does it create a new field of concurrent jurisdiction?
So the court does talk about this area of law as being a double aspect or concurrent area of law. The federal government can be there because it has the authority under 9124 to deal with Indians and lands reserved for Indians. And the provinces can be there under sections 92, 13, and 16 because those give the provinces the ability to deal with children. And so both of those powers are there, and that the coordination agreement function is attempting to harmonize those. I think what's missing is the concurrency of the First Nations inherent jurisdiction sourced in our own Anishinaabe or other legal traditions as being from prior to the arrival of Europeans, surviving the assertion of sovereignty, not being extinguished, and being something that can be exercised today. So true concurrency would recognize that we're not just dealing with a federal or provincial authority, but there is an Indigenous authority that is necessary to and really underlies the other coordinations or concurrencies or triple aspect, or whatever you might want to call that's there. And so I'm really hopeful that this spells the beginning of that concurrency, that harmonization, that reconciliation. But there are challenges with that. Again, the court hasn't spoken about it in its own jurisprudence, and it could be that as a legislation could be removed by a subsequent parliament. And so there's a tenuous nature to this in terms of how we think about this through federalism lenses. But on the ground, Anishinaabe people, other peoples, aren't just going to resile to that understanding that our laws are only sourced in federal authority or are operationalized through provincial means. For hundreds of years, we've been insisting on enacting as caretakers of our children. And even though they were taken away in the 60s scoop and taken away in residential schools, there is something more foundational that is present in that, I think, is going to, if we're going to have any success in this area, be the basis of that concurrency, that harmonization, that reconciliation.
Thank you. For those of us who know about child welfare law more generally, we know that the paramount principle is the best interest of the child, and that there are very different perceptions of what that means. It's a broad term with many factors. And so while the Bill C-92 in particular emphasizes the best interest of the child, whose interpretation of best interest will prevail in cases of conflict between Indigenous laws and provincial standards, and how will the Act navigate these potential tensions between individual rights and collective rights within the Indigenous communities? I want Sarah to respond.
I want to give a shout out to Bryce Lansdale and JC Steele, who basically wrote the answer for me. So according to section 22 sub 3 of C-92, if there's a conflict between an Indigenous law that has the force of federal law and provincial laws, the Indigenous law will prevail. So again, that's a great tool that Bill C-92 is built on. I love the Quebec Court of Appeal terminology, or maybe it was just a bad English translation, but the constitutional architecture of the division of powers, which is such a mischief maker for Indigenous peoples. So the way that this section works, the provision of the Indigenous law does not, the subject of the provision, let me read this right, does not apply if the provision would be contrary to the best interest of the child, because there are certain things. There's a nice little table that I worked on with another good friend of mine from OKT, Sinead Dearman, and so the table of basically what's superior in the legislation, and of course the Charter of Rights is something that Canada always wants to reach in and say applies to Indigenous jurisdiction. And that's a question that still has to be answered because we have the divided Dixon case. Basically, we'll have to see specifically a case where that decision is applied. But this best interest of the child test is section 23 of Bill C-92. And again, I'd like to test the associates that works with me. What are we talking about when we're talking about best interest of the child? We're talking about child apprehension. And we're supposed to be in the era of prevention, right? Supporting, as a community, as a nation, supporting our families so that they can take care of their own children. And if they can't, then the extended family system, depending on the cultural ways of the nation, steps in. And so this best interest of the child is going to be a mischief maker for true Indigenous jurisdiction. Because if we want to be prevention focused, we want to use cultural ways to support the children as we always have. The best interest of the child and child apprehension is still going to make its rear its ugly head. And I often talk about Nunavut in this situation because Nunavut has a pretty good law. But what is actually happening is the child welfare workers are coming from the south and doing what's familiar to them. child apprehension. So we really need to be careful as we're exercising Indigenous jurisdiction that we are fully doing systemic transformation, including the proper training of all our social workers.
So we have questions really for everyone, but I'm going to start with Maggie, and it's how does the legislation in the US, but also how will Bill C-92, as we call it, for shorthand, address situations where Indigenous children belong to multiple Indigenous communities with different Indigenous laws? Could this lead to jurisdictional confusion or gaps in service provisions? And how might we learn, or Maggie, then, from the implementation of ICWA in this area?
So thank you so much for that question. I wanted to just make a couple of comments about points that have been made, a little bit of clarification also about the US system before moving on to the question, if that's okay. I think that there was an earlier comment that the distinction in systems in systems of colonial law between Canada and the US are somehow intrinsic to the US constitutional framework, as if in a certain way that the US government gave Native people south of that border the system that is much more benign than the system, of course, that's up north, which is far less empowering. And so just to press back a bit on that and to describe the fact that what happens within the territorial borders of the United States is a result of the advocacy of Native and other colonized people, sometimes literally by going to the Constitutional Convention to shape the Constitution itself in certain ways, but also then holding the United States to a certain vision of sovereignty and recognition of that sovereignty that preserves those principles like non-intervention, community preservation, collaborative lawmaking, recognition of territorial sovereignty, recognition and self-determination. So all of those visions are things that Native peoples have shaped and advocated for, and they exist south of the border because of certain tactics that I think could be helpful in applying in many different jurisdictions. These colonial governments have borrowed from each other. We had a 60s scoop here in the US. The technologies of boarding schools have been exported worldwide. The science of colonial administration and the laws of colonial administration have been exported to where we're now having an ICWA conversation with Canada. And so I do think that there may be a space for colonized people to further, and I think once again, to begin to communicate cross jurisdictions about those strategies that have been more empowering in one colonial jurisdiction than another, and seeing it not so much as the benignness of the colonial government, but actually the fact that there might be different strategies that might result in different solutions, especially legal strategies, forms of legal advocacy. Okay, that said, the implementation of ICWA and of Bill C-92, especially in the context of children with multiple communities. So there were a few questions about group rights and individual rights, and of course, trying to balance those things in the context of conflicts. Brackeen dealt with one part of ICWA that might address some of this question, which was a placement preference. So in ICWA, the Congress used federal law to preempt parts of the state best interest standard to place placement preferences for Indian children, so children who are either tribal members or eligible for tribal membership, to place them with their own extended family, their own community, which would be preferenced. And of course, in the US, we only allow one form of tribal membership. You can only be a member of one tribal government at a time. And so that would be the resolution. But they also had a preference in the third space of other Indian families. And this came up during the litigation because these were challenged as being seen especially problematic as a racial category. by saying that you would take a Navajo child and put that child with a Penobscot family, that sounded more like a racial preference than if you would put a Navajo child with a Navajo family. And so there are a few things to think about in this context that I think get to your question, especially about conflicts. And this is going to be, a broader, an ongoing conversation. But first, in the oral argument for Brackeen, the attorney for the tribes really dealt with this question very well by saying that multiple tribal communities have been settled on certain reservations. And so oftentimes by saying other Indian families, you're actually going to place that child with another family within their community that they have a relationship to, but may not be enrolled with. And so there's a way that that catch-all provision will catch those communities, especially broader identity of Native children. My son, of course, is both Ojibwe and Shoshone, and what in the world would happen with him is both a sad and just a thought process I don't want to think through, but of course is implicated by this. The other aspect of it is to see these laws as keeping children within communities that have been colonized by the United States, not a racial category, but jurisdictions over which the US exercises the power to colonize, to come in and run governments for sovereigns that have never consented to its oversight and still continue to be recognized as independent governments, although part of the US is brought into it, but still colonized by the US. You can see this not as and I think Sarah's response got to this a little bit, this isn't a group rights, this isn't about pluralism and distinction necessarily of community. That, of course, needs to come into the conversation. But what we're talking about here are tools of colonial administration. Colonized governments cease to exist when they're stripped of their citizens. So it's a tool of colonialism. You end those communities by taking away their children and socializing them into whatever view is held by the colonizing government. It's been practiced all over the world for hundreds and hundreds of years. So it should be seen very clearly as such. So by taking that child and putting that child back into these communities, it does two things. One, it mitigates that colonial effort. And then the second thing that it does is it reminds, especially under the best interest standard, it reminds that adjudicator that we have debilitated, we control these people's governments, their well-being entirely, and we have debilitated them intentionally for decades, if not hundreds of years. So to take away their children now is really just another mechanism of this long-standing project. And so to understand what is in the child's best interest in ICWA, for example, part of the best interest of the child standard requires the states to try and keep the family together by providing the right services to that family, by providing the right forms of support. And you can see self-determination as actually part of that, and the mitigation of colonialism as part of the best interest of the child standard, because not only are you now forced to return the child to a colonial context, maybe you should improve that colonial context by supporting the self-determination and self-government of those communities in the first instance. And so I think that the group rights, individual rights, I understand the tensions in liberal discourse, and I understand the scholarship around this area has been deep and rich, but the conversation about colonialism, its mechanisms, and the fact that it's everywhere, we're not having group and individual rights liberalism conversations. We are literally having a conversation about colonial administration and what that looks like. And you colonize by taking people and taking children, mostly women and children are the focus of those apparatuses. And so those should be points of, at least, they're not going to settle the normative questions, but they should be better informed.
Thank you. I want to give John and Sarah both opportunities to answer these questions.
I think that there's room for considering these questions from the perspective of Indigenous people's own normativity and the laws and standards and principles and processes that we would also want to see implemented through this law. And so I'm wondering about the conflation of Indigenous citizenship or identity with blood, with a particular phenotype or racialization or ethnicity, when, for thousands of years, our people were, what we might now call Potawatomi, Dawa, Ojibwe, Kickapoo, Cree. There was a lot of intermingling in between clans, Otter clan, there would be Bear clan, and Deer clan, and Eagle clan. And we wouldn't have any problem with recognizing. In fact, we would love to see that our children are joined to different communities, because that gives them greater strength in the world, gives them greater options in the world, allows for them to learn more about what the possibilities are of being human and have support in those settings. And so conflating Indigenous identity or citizenship with a particular band or a particular political organization doesn't do justice to the richness of our historic and our contemporary ways of being, given that 50% of us are marrying outside of our bands, as it were. Our children have this amazing opportunity to keep all the good that you have and add to it. And so I would love to see resolving these tensions by leaning into the Indigenous normativity of these questions, where you try to have the options available for the child, and then have the system operate that acknowledges the colonialism that is being talked about by Maggie, and pushes back and displaces that colonialism, but not doing so by kind of replicating another colonial tool, which is to act as if we're just of one identity in the world and aren't complex, nuanced people with all sorts of ties that are potentially nourishing to us.
Yeah, I mean, there's pushes and pulls on this question too, right? In reality, so many of the nations who are sort of in the PCD, per capita distribution sort of time frame, have moratoriums on transfers and things like that, which of course impacts child welfare. And jurisdiction is a difficult question, just because the practical realities is that the pie is so small, and sharing the pie with more people is a real problematic situation for some smaller First Nations, and even bigger, larger First Nations. If there's royalties and revenue sharing and things like that happening, that just kind of muddies the water. But in the act, it's section 24(1), where it says that the courts are to determine the community into which the child has a stronger tie, and looking at factors like in residence or the child's view or in preferences as well, and given the age and maturity of that child. The Indigenous laws that are coming out too are wrestling with this question, and Cowichan's approach is basically that the nations themselves meet and determine together what's the best interests of the child as far as jurisdiction. And the Louis Beau law in section 3.4 basically says that their law, they decide. It's the paramount of the law of another First Nation. So those are different approaches. I think there's probably a teaching in Anishinaabe law about this, and having those conversations with clients to talk about all the what ifs is our role as lawyers.
So Sarah, you've anticipated the next question somewhat, because as we know with child welfare, resources are always something that are scarce. And they're also, as you said, I mean, we're with this apprehension approach where, which itself is very resource intensive, versus helping families with their keeping their children and the resources that are necessary. So how will the Act, and I don't know if it's the Act that does it, because I think that's the problem, ensure that there is equitable access to resources and support for all Indigenous children, regardless of their community's location or capacity. And I'll throw it back to Maggie as well in the US situation with ICWA about the lack of resources that are out there for child welfare. And we know that part of the context is also the settlement was just turned down for sort of the claim around inequitable resources on reserve children in particular. But I'll throw it back to Sarah and then we'll come back to Megan. So.
Yeah, so thanks to Cindy Blackstock, we have a good sort of snapshot of sort of the minimum because all the First Nations across Canada that under that federal program got a profile of funding that I mean there are some disparities in it for sure the way that it was allocated, but every First Nation sort of knows what that floor is for substantive equality regarding child welfare. And that settlement that was just said no to is being not enough. Also stated in the agreement that any nation exercising jurisdiction, any Indigenous governing body, that would be the minimum that they would get for providing that type of services. And of course, in the exercise of jurisdiction, we go beyond that, right? And so there's been some fairly good numbers coming out of the fiscal agreements that we see that are announced in media releases, some pretty good numbers. But I think one of the things that's going to be a problem is what we just talked about, citizenship. So everything is tied to your status members. And some of it is tied to the status members on reserve. And of course, we know because of substantive underfunding in First Nations, it's a difficult place to live. And so some like my nation, my First Nation has like 20 to 25% of the members on reserve and the rest off. So it's hard to build great services with those small numbers of people. And many of them living in neighboring municipalities, it's still, accessing some resources from the First Nation. So all that is to say that there is going to be resource disparities, but there's been some helpful Canadian human rights tribunal decisions that we use at negotiation tables in order to, and we also look at the Act, Section 20. Section 20 is helpful in the Act to try to negotiate up from what we know is the minimums in the long-term form of child welfare.
So Megan, do you want to address that from the US perspective?
Yes, so ICWA, in addition to preempting state law and requiring certain forms of state record keeping, also transferred a system that had been established for states for contracting, compacting, and funding around Native child welfare to tribal governments. And it also reaffirmed the inherent jurisdiction of tribal governments over child welfare questions within their reservation borders. And I understand that this system, similar to Canada, which I know far less about, but is a system where those inequalities, of course, are very real, and where many tribal members live off the reservation. So there are ways that the state system is, of course, the preemption is necessary because many tribal members are going to fall within state jurisdiction just because they're off the reservation. However, the mechanisms within ICWA that established these systems were really put in place because when the US began its big social welfare push, especially with the national government funding state governments, the development of public schools, all of our social security, disability benefits, old age benefits, really came during an era where the federal government was trying to shut down boarding schools and to place Native children under state jurisdictions, and states refused that jurisdiction. And so the federal government started developing apparatus where they would even hire state social welfare agents by contract and pay them and have just so that agent would oversee Native children. And so through contracting and compacting and literally block grants to the state governments, the federal government was able to force the integration of state children or of Native children into the state system by contracts with school districts, to force them to integrate Native children into the public schools. And so with ICWA, the vision, of course, at its best was to take this apparatus and to push it back to tribal governments. And so that's a push that we need to both remind the federal government of and to push for further, so tribal governments can begin to even further develop their welfare systems around child welfare and family welfare. It's just a huge deprivation of resources, of course, within Indian country generally. However, you do have often more resources, especially through Indian Health Service, especially like Alaska Native Health is a little bit more stable than Indian Health Service, but you end up with more services through the tribal government than you might have in those rural communities around the reservation. And so I think pressing infrastructure back into tribal governments that have partial systems and having them develop further, because they have often tribal governments develop forms of Head Start and pre-K that you don't actually find in the state around tribal governments, because the U.S. is strangely, we have the social welfare happening within Indian country that you all have elsewhere within Canada. Our network is falling apart in both places, but you can have places like Oklahoma, where you have a governor that's so hostile to any form of social safety net for any children, including feeding public school children, that Native tribal governments might actually be a place of preservation of those values, where Native kids can at least, and hopefully, as they did with the COVID vaccines, even start caring for communities nearby, because they're able to operate in such a way that they can reach out into rural communities that more hostile administrations just don't have the apparatuses for under the state governments.
Thank you. So both the Brackeen case and the reference are decisions by the highest court of the land in terms of constitutionality of the scheme and the legislation. But the next question really is, how are we seeing lower courts interpret and apply this legislation on the ground? And are there different interpretations, like need inconsistencies and uncertainty? And I know, Sarah, you've already talked about the potential for First Nations not to go to courts or to set up their own kind of tribunal system. But we'll start with you, Sarah, to talk about that.
Thankfully, I have a complete answer to this question written out for me. So the courts have interpreted the act primarily focusing on how it intersects with prevention legislation. So the best interests of the child under Section 10, courts have grappled with reconciling the Provincial Act with the Federal Act. So in BC, they found that the Federal Act requires the best interests of the child to be considered at all stages, while provincial law may limit this consideration to specific instances. And Ontario courts developed an augmented test to incorporate federal considerations into provincial assessments. And courts in Saskatchewan and Manitoba have similarly attempted to align provincial and federal standards, often giving precedence to provincial. Again, this is because it's familiar, and unless directly conflicting with the Federal Act. So the effect of service under Section 11, of course, have mostly cited this section as authority without deep interpretation so far. However, there's an acknowledgement of the Act's emphasis on cultural continuity and substantive equality, with some courts viewing it more as a guideline rather than being binding, unfortunately. And then Section 12, significant measures. The this is really what we've been watching, because our clients are getting ready to exercise jurisdiction, they need to know where their children are. So this is section 12 of the Act. Alberta courts have interpreted significant measures to include various guardianship and custody orders, emphasizing the importance of timely notice to relevant parties. There's some conflict between federal requirements for notice and provincial mandates for timely decision-making, with provincial law often precedent. And as far as section 13 and representations and party status, courts have noted that the Act's allowance for care providers to have party status, but not Indigenous governing bodies, although some courts have allowed these bodies to make representations in cases without full party status. And there's a Manitoba King's Bench decision called the Director of Child and Family Services and PLG, and it confirmed that a court order is not required for the agency to disclose information that enables the IGB to meaningfully participate in the court process. So just this snapshot.
Thank you, over to you. How is this being, ICWA being interpreted? Open board.
And so we've had ICWA since 1978. And so ICWA was interpreted, I mean, it was largely, from what I understand, not applied properly. And so in some ways, the visibility of the Brackeen case may make state judges more aware of its existence, and might have them asking more readily about whether or not the children that they are that they're placing are Indian or not in the first instance. The law wasn't taken seriously, or as seriously as it should have. And so what was left behind in Brackeen is an affirmation of the power of the United States to pass that statute, but the United States stopped short of answering the question whether or not that law violates equal protection principles of the United States Constitution, specifically in its Fifth Amendment due process clause, because it's the federal government. So it's not the 14th Amendment, but the question that remains after ICWA is really one where the same parties that are mobilizing to press back on the recognition of inherent tribal sovereignty within the US and the mitigation of American colonialism are trying to take that same argument to different fora and to different statutes. Because getting standing to challenge the Indian Child Welfare Act may be difficult, but challenging other statutes like the Indian Gaming Regulatory Act, or even just trying to reinforce birthright citizenship for other colonized people may be another avenue to try and destabilize this system. And so the lower courts are, with ICWA, of course, the Supreme Court just sort of left things as they were. But the lower courts are burbling a little bit around, or at least allowing through, as the federal courts are often doing now with these really intense challenges to certain forms of constitutional vision, they may let these other challenges through. And I think that's a burden on us all to begin and continue these conversations that the Supreme Court left open about constitutionalism and American colonialism, about constitutionalism of things that we deal with as far as human enslavement and those forms of constitutional failure, of racial discrimination, and of this colonial apparatus that could be rendered deeply suspect if we start to apply other forms of constitutional principles to it. Constitutional principles that have never been applied to it, nor were they developed for it.
Thank you. I just have a couple of concluding questions. Sort of, we have been actually, I mean, the answers so far have also been looking forward, but more specifically, I want to turn to John and say that, like, while these cases focus specifically on Indigenous child welfare, what impact will these decisions have on Indigenous sovereignty and self-government more than generally?
So when the court talked about section 35(1) in the Bill 72 case, section 35(1) being the existing Aboriginal treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed, they noted that their past cases have not recognized a broad right to self-government. They cited a case called paramount. And they said, at the same time, we've never considered a matter as fundamental as the culture and identity of Indigenous peoples in the field of child and family services. So there's a signaling that there might be an ability to distinguish Lejeune from another case that comes forward and considers the right to self-governance over child and family services. So there's an opening. I'm a little troubled that the court is seeing Indigenous self-governance in the light of culture and identity, when what is the wording of Section 35(1) is the Aboriginal peoples of Canada. We focused on Aboriginal and what Aboriginal means. We've not modified that or focused on peoples to the extent that we should. And this decision doesn't give us any confidence that peoples will be the unit of analysis in subsequent decisions. So there's an opening here, but there's also a myopia in that opening that continues to regard Aboriginal rights as something that was integral to the distinctive culture of Aboriginal peoples prior to the arrival of Europeans, again, focusing on the Aboriginal dimension of things. And so there is space, but the space is to be populated. And I think that's the work of communities in implementing the laws to show that for what it looks like in practice, to act as peoples and to take us beyond these ideas of just culture and identity as the exclusive markers of governance. And I want to just say also that we should not forget for a moment that law is more than just what legislatures and courts and executives do. Indigenous peoples have customary law, and that law itself should be breathing meaning into the understanding of these rights, obligations, duties.
Maggie, do you have something you want to add to that question from your perspective?
I think Professor Burrows is exactly right, and on all fronts. I think the only thing that I would add to that is the idea that the frame of what colonialism is and has been, it looks very similar across all of these places. These governments have done the same thing to many different groups of people who look different and act different and speak different languages and have different spiritual views from one another. And that, and so our claim to self-government and self-determination should not come from any kind of claim to even a sense of difference or a sense of culture or different, but instead the fact that these are our communities, our political communities that have been wrongfully governed by civilized nations, European nation states who felt that they had the power to do this, that do not have the power to do it. And so the more that we can learn and have those conversations and push back on it, not just that we have our own laws and our own governments because they're different, but because we just have always had our own laws and our own governments, even when they're the same, even when they're different, and that we shouldn't have to prove any kind of notion of separateness from that, but that the separateness has been so long-standing, and that these governments have been so impinging upon self-determination very, very clearly for decades, if not hundreds of years, if not longer, that we should begin to have a conversation about what decolonization looks like in these contexts, and also draw from other models. So in the US, for example, we colonized the Philippines, and then we set up a 10-year apparatus through the Congress legislatively to walk towards forms of self-determination before it established a mechanism for recognition towards independence for the Philippines. There are legislative and constitutional precedents all over the place for what we could do to start to build different and better frameworks towards different and better forms of colonialism. And my hope is that we can start to learn those lessons, especially when we get out of the idea that we're only looking at Indians or we're only looking at Aboriginals, because these countries colonized other people also. And they did it to exploit them and to govern them towards civilization. And so we can also learn from those other examples rather than having to back ourselves into a corner about culture or difference that we necessarily have to prove. I believe that those things are there, but that shouldn't be the entire basis for a normative argument for self-determination.
My last question is for Sarah. Given the work that you're now doing, working with First Nations, developing the systems for child welfare under the legislation, what legal strategies might Indigenous nations take in continuing to practice their rights around child welfare in particular, and also self-government more broadly?
So Bill C-92 is not just the Section 18, so there's these national standards that are parts of, that are important. I had an interesting conversation with a friend I met here when I did my Master's of Law, and she was also writing a thesis, and we had a conversation a couple years ago, and she's a Crown lawyer, and she couldn't even think about having Bill C-92 like legislation without national standards. And I was thinking to myself, yeah, because the national standards are something I have to sort of like, there's sharp instruments that we have to sort of work around and navigate around the national standards, because they come from, I always talk about this when I'm working through legislative drafting for our laws. There's this idea that I read when I was doing public administration lately, that in my undergrad, and this idea of this mango thesis. So the mango thesis is like, you can't take the seed without taking part of the fruit. And so is we're looking at different sections, is a lot of lawyers are doing wrongly, is taking like Taoist's law and making it another nation's law. You're taking their policy decisions and making it your own. And so this is, the national standards is, it's a bit of the Canadian fruit that we have to live with. The Charter of Rights, Canadian Human Rights Code, and we have to sort of live with it, and it does damage. The other thing too is like the governance part. So Indigenous governing authorities are chief and councils, therefore we have to live with the Indian Act. Or it's a agency approach where we have to live with a provincial or federal not-for-profit scheme. Again, come back in thinking the root again of somebody else's methodology of governance. And one of the things that I've been trying to work on is through our own exercise of jurisdiction, creating our own institutions. That's all about UNDRIP and implementation of UNDRIP, creating our own Indigenous institutions in our own way, with not having to adhere to the way board governance works in a not-for-profit legislation here in Ontario or another province. So that's things that we're thinking about as far as pushing the envelope. But there are a lot of nations that are not exercising jurisdiction, but they're just using the act in a rather relatively friendly relationship with the provincial governments to like do prevention in a real fulsome way. And I think about the India and Labrador and working with the province of Newfoundland. And also pushing through the inquiry, like they're really doing child welfare in a self-governing way, but without their own legislation. So it's all really interesting stuff going on.
We have a very short period of time for any questions. Are there any questions from the audience? We can have a quick answer to.
So following the Bill C-92 decision, Quebec completely stopped negotiating with a few communities, and are not answering any emails or really withdraw. So I was wondering, in terms of honor of the crown, how does Bill C-92 binds or does not bind the province to really engage in these negotiations?
I don't know, Meg, if you were able to hear that question, but it's focused on Bill C-92 and Quebec's response to it.
Yeah, so we have this doctrine of the honor of the crown, which says when the crown makes a constitutional promise, that has to be diligently fulfilled and according to its object. The question is whether or not there's a constitutional promise here made by the federal government that engages the honor of the crown in that way, and it seems as though that is at least got some potential. But in the provincial context, the province's honor is not engaged by pledging that through the legislation at the federal level. But you have a Quebec Court of Appeal judgment that recognizes the inherent right to self-government. And that has not been commented upon by the Supreme Court of Canada. Supreme Court of Canada said we're not going to talk about the right of self-government. So in my view, in Quebec, the law is that there's an inherent right to self-government under Section 35, that the honor of that crown requires acknowledging that. If they're infringing that right, it has to be justified. And if they're not answering emails or acting in ways that are upholding what their highest court in that jurisdiction articulated, then they are in breach of that honor, even though it's not legislatively created. It's even more broad in that jurisdiction than you would find through the federal.
Thank you for that excellent question. It's a good one to wrap up with. Just in light of the time, I just really want to thank our speakers. And I also want to thank the working group students who, because of the deep dive that they've taken into these two cases, crafted some really good questions that made me look really smart too. So thank you to everyone who participated in today's panel.